Okay,
I
and
love
we
that
are live.
intro. That
You
is
love the
the
intern?
theme song. Love it.
Yes, yes. It's wonderful technology, the ability to introduce reels through Facebook, and then you can download them. So we are live again. We'll give people a couple minutes to join. Usually the stream picks up, throughout as people see. We get the red frame, the word live. Some people had questions if there is a link, but the link is actually your profile picture. Um, and it will be, of course, recorded and preserved on YouTube and Facebook. It's been live streamed simultaneously there. So for those who are joining, we are here. It's TMP and Roman Brick again, and we have a brand new guest here, Marc Fishman. He might be joined by his attorney later on. He's driving. Has been detained, not like James Kelly, and I wanna say a couple of words about that, but actually delayed by family court. So hello, Mark.
Hello, Roman. Hello,
Excellent. Good.
Matthew.
Yes. Good to see you guys finally together. I'm playing with the different layouts. Excellent. Okay. So again, the goal is to make this show as interactive as possible. I see viewers coming in. You should see the banners, right? So you guys will be able to see the comments, and we'll stop throughout in order to let people interact with us. I think that's what makes it all interesting for us. Let me start off just really briefly for those who don't know. James Kelly, he's a very much known fighter, liberty fighter here, peaceful, a very knowledgeable gentleman, was arrested on the spot 2 days ago, attending a court hearing for another court victim, a woman. I made a stream with her, Tracy Arms, and he's still being held in the county jail in Suffolk County. So everybody, please, who sees that, who see the materials that we are posting, the updates, please share them far and wide. There's an effort behind the scenes to get him out. Habeas corpus has been drafted. I saw the draft is actually circulated within the group of people who are concerned and want to help as much as possible. Those who know James Kelly, he is completely peaceful. He's an amazingly knowledgeable pro se who could possibly easily pass the bar. As far as I know, as far as I've seen his knowledge, he never did anything even remotely violent, threatening, illegal, and he was summarily essentially sentenced to a jail for 30 days. Right now, he's been actually denied the fundamental things. His glasses. He is in his 50s, so without his glasses, he's ineffective. They took his glasses. My understanding is under the pretense that the glasses can be used as a weapon, which is insane. But they rendered him ineffective even while his liberty is taken. You have any comments, Matthew, on that? Mark, maybe you.
I do have a lot to say on the topic. I didn't want to be too long-winded, but I'm really disheartened when I hear about, litigants, pro se litigants, family court pro se litigants getting arrested. It doesn't seem like it's appropriate because the point of incarceration is to segregate from the rest of society, to segregate those individuals who are violent. And this to me seems to be nothing but punitive in nature. And there's no due process. I mean, I don't know all the facts, but it's my understanding there was no lawyer present. I mean, if the judge wanted to be a witness, so to speak, and bring a crime or bring charges or contact a law enforcement agency, who in turn would convey it to a district attorney, that'd be one thing. But this idea of a summary adjudication where they are basically a judge, judy, and executioner, it's just really, I think,
Yeah.
inappropriate.
Yeah, Mark, you know him personally, right? I saw the letter that you wrote, and you're also active in the Prominent Fathers group, and Anthony Cancel, right? Also sent. So you wanna add your perspective?
Absolutely. James Kelly is a disability advocate and a technology expert who has helped those of us like myself who suffer from traumatic brain injury with hearing and cognitive impairments. James was instrumental in getting remote technology to work so that I could read the words on the screen because I don't always register spoken words, particularly in noisy settings. James and I appeared with Blaise Gomez in January this year regarding all of his advocacy and assistance with meaningful, effective communication for those of us with disabilities. He's a true gentleman, a true warrior, like me, doesn't get to see his kids, but, fights for the cause daily. And it is very concerning that a family court judge named Judge Graff appears to be retaliating against those who volunteer and assist and help the less fortunate, those who struggle in family court, no one more than, victims of domestic violence, those who are disabled. And to arrest someone who's trying to make a effective communication record that many of us need, because we won't remember what is said, 10 minutes ago or a half hour ago, and to not have due process and just be jailed. No words, no words. Family court in New York is like we discussed. It's like communism. It's like the Gestapo. There's no due process. Family court jailed me, very similarly. When I made a big deal about family court Judge Shower in Westchester denying my note taker entry to the courtroom. I had suffered from a recent car accident a number of years ago and couldn't take my own notes. I had cubital tunnel syndrome and carpal tunnel syndrome, so my fingers were numb and didn't hear too well. Got an order from the ADA advocate to have my note taker come into the courtroom, and Judge Shower blocked her, while my ex-wife was allowed to bring in 6 or 7,
Yeah, we'll get more. This stream actually is dedicated to your case, to your federal case, which is particularly interesting. Matthew and I, we covered his federal class action during the last 2 episodes, and generate a lot of interest. We actually were blessed with the viewership of hundreds, and I think our first live stream actually it's probably crossed 2,000 already. So
congratulations, well done.
Well, it's that's not the goal. The goal is to spread awareness, right, and provide information and the tools, right, for those who don't know what they can do. They're not familiar with maybe with the technology and even the thought process, which is very important. But okay, so that's one other question that I have for you, because we need to people need to relate to it on a personal level. But you saw him personally. Would you describe him as, because my impression is there's nothing even connecting the word violence with James Kelly. He's completely mild-mannered, well-spoken, soft-spoken man. Would you concur from your experience?
James is a gentle giant. He's the guy you call if you need advice. He's the guy you call if you got to find out the name of a transcription service to do an immediate transcript. He's the one to call if you need to check your law, your references. Always volunteers, always is solicitous, always is gracious. As Matthew said, it serves no purpose to jail someone like that, other than to send a strong message to those of us in the disability, the veterans community, that advocacy doesn't matter and civil rights don't exist in state family court in New York.
Not only in New York. That's the key theme of this show, at least, is that it's everywhere. We need to understand that it's nationwide, it's across all states, and it's actually global. It's in every country, in every state. It's part of the global agenda, worldwide agenda. It's communism. Again, I will not tire from repeating that. But I was born under communism, and I know when I see it. So that's a key topic that we'll cover. But okay.
But
so
Roman, keep in mind we have 8 states, including California, that don't allow disability to be used against you in a custody or visitation proceeding unless there's an extreme risk to the child. If the risk can be accommodated, it gets accommodated. So states like New York, where basically civil rights don't exist, are places where people get locked up who want to assist others with communication, as James was doing with Tracy that day. So yes, we do have differences in states where some family courts, not just unique to New York, just regard their courtroom as a kingdom, and the judge can do whatever the hell he or she wants without regard, without checks and balances. until some of us sue them in federal court and pierce sovereign immunity. In the rare instance we do.
Yeah, we have an expert in California law, so he will probably, opine on that. I'm not sure the difference.
Well, you know what I did want to say? There is one thing I did want to add. The term victimless crime really comes to mind when you think about the James Kelly situation. People sometimes say that prostitution or drugs is a victimless crime, but there's a comeback because drugs and prostitution may, to some extent, debilitate society. But if you look at something like bringing, I don't know what he did, he was filming or had cameras or some such thing. And I don't see who's harmed by that. Nothing got broken. There's no out-of-pocket expenses based on what James Kelly did. And it just seems to me that the court is upset because somebody didn't follow the edict word for word, and it just seems really the whole thing seems so unfortunate, and it's just really disappointing to hear news like this. So.
Yeah, but
Yeah.
Matthew and Roman, let's add a point to this. New York family courts are notorious for not producing an accurate transcript. When the family court judge does not want her words transcribed, she will call up, or he will call up, the transcription service, and suddenly those of us get a transcript that has 13 or 14 inaudible words on the page. Because in New York, we don't have live court reporters, we have digital transcripts. And then other cases, they'll say, oh, I don't like what I said, I'm going to edit it, but you can't be in the room, Mr. Fishman. I'm going to edit it, and this will be the transcript. And other times, like we just found out in the case I'm involved in, like the one you referenced in 2018, the court reporter is, quote, unwilling to produce the transcripts. Why? The judge recused. She denied a disability accommodation. Where's the transcript? We're unwilling to do it. Okay, but you have the records. Have someone else do it. No, we can't do it because she did it in longhand. And no one can decipher her symbols. Did you go to a forensic court reporter? No, you have to sue her. I have to sue a court employee because she won't do 2 transcripts, which means I can't appeal my case. So there are reasons why people like James have to take a record or record in the courtroom, because those of us suffer daily without the ability to get transcripts when they don't want us to have transcripts, when they want the record distorted, or when they want to make up what their version of the record is. And it's important that this gets exposed, because it's got to end. If we can't have verifiable, accurate transcripts and videos of what actually occurs, then there is no record of the proceeding, which technically means there is no proceeding. It's just a circus.
Yeah,
Right,
and the insidious part is that they force you to affirm that the record is accurate, right? Where you have no ability to independently actually verify it.
Well, you do. So I had a transcriber. His name was Alan Kachowski, who I took from the book and who transcribed my stuff for years. And then after I sued in federal court, they went after him and said it's his fault the transcripts have inaudible words. And they suspended him, okay, because they said it's your fault. Yet the person they replaced him with had double the inaudible words that he had. And if you would see, that Court Administration New York actually wrote a report on New Rochelle and Yonkers Court that the courtrooms, Matthew and Roman, were inaudible because they were in these makeshift office buildings where you heard everyone talking outside. And if you have a disability like me, you just hear echoes. And so if court administration said the courthouses aren't audible, how would you expect a disabled person to understand anything? How would you expect a regular person? You wouldn't. You'd rely on a transcript, which you get back, which is inaudible. And so then what? You try to appeal it and you can't even make your argument. So a lot of these courthouses are pre-World War II or pre-World War I in New York, and they don't care that they don't take a transcript. They don't care that you can't hear or register. So those of us, sue in federal court and get orders for real-time transcription, well, they actually have to give us an electronic real-time transcription. Like I got an order from the Second Circuit on July 16, 21, that they provide this. Like you have words going across screen, they have to provide in court. But then again, here's the problem. They're supposed to, and there's a federal order. But what happens if they don't abide by it? You go back to federal court, you're going to hold one of these judges in contempt. A lot of these judges in New York and elsewhere just think they're above law. I don't have to provide it, so what? Sue me. It's sad. It's a very sad day. So, hopefully we'll get meaningful change and get transcription and recording accuracy from James and other sacrifices to be tortured in a hole for 30 days for trying to help someone get an official record.
I think Matthew had something, a note to add to this particular topic, right? And then we'll just dive into your case, Mark.
Well, I didn't really have a lot to say other than I would think that if you had to construct a court system from the ground up, it seems to me that the people would want, or the court system would want to have some kind of reliable way to record everything and have recordations, absolute word for word of the proceedings. You would think that the court system would be eager and hungry to make sure there's everything is official. And it doesn't cost very much money just to simply tape record everything, have everything audio and video, just like we're doing right now. The technology is so abundant, it's so in your face, it's so ever present. But why don't they want to use it? And then it almost makes you wonder, are they hiding something? Do they want to hide? Do they not want to be exposed to scrutiny? And everyone that I talk to seems to have that opinion, that they really want to hide from the public spotlight. They don't want any kind of transparency or accountability. They want to be able to screw people over in their little private star chamber situation, which I think is but to me it just goes to show you this smacks of communism. And to me it's just utterly abhorrent. This is not about the red side of the aisle or the blue side of the aisle. This is just godless communism with total disrespect for the Constitution, and it just really doesn't seem to make any sense. And I just hope that all court systems will just adopt a per se rule of recording everything so there's no dispute, and it's but you never know.
Yeah, that's actually such a great point. We can maybe dedicate a separate live stream to that. But you brought up technology that we have right now. So this thing, what we are doing right now, the stream, right, the transmission is being uploaded to YouTube and Facebook, and it's being transcribed in real time. So people who are watching that, they potentially can see the words. It's unbelievable. So you don't have to have any human being involved in the process of providing the accommodations and, of course, recording, transcribing. You can review it afterwards. But it's what people need to understand, that the obsolescence that we are seeing, the delays in development, they're not by chance. They are intentional. The court doesn't want to go forward because actually stepping with the same pace with technology will create transparency, and everybody will be able to see what we experienced, all of us collectively and individually, as fathers, as litigants. But anyway, that's so it was important for me, and I know for you as well, to make sure that James Kelly is mentioned, because what people who describe it, God forbid, that's what they want to know, that they're being exposed. What has been done to them is being exposed. So his name will be repeated again and again throughout every post and every video that we are making. But with that said, potential remedy, right, that we are discussing here in the show, Matthew, and that's why the idea came to invite Mark. Potential remedy can be federal court. So can you walk us through how did you get to the situation, Mark? What necessitated your appeal to federal judges to save you from the state court? How it all started?
Well, I'm glad you mentioned that, because I want to talk about a law that we have in New York that some aren't aware about. It's called S5533B. And basically what it is for those of us who are hearing and memory impaired, I have 2 neurostimulators in my chest. I have a electric neurostimulator in the rear of my left ear, and I have tinnitus. So I am using, real-time transcription on the screen. I use it on my cell phone. I use it at home, my phone in day-to-day life. And so the reason I mention this to you is that this law required New York State to make all courtrooms have what they call CART, real-time transcription, with a printout that you can take with you, that you get immediately. But New York State courts don't feel they have to answer to anyone. So although we asked for this accommodation, in my case, in 2017-18, they said, you're not disabled enough. after they had all their forensic people say you have a hearing impairment, you have a memory impairment. After we had Disability Rights New York, the advocacy organization writes the court saying you have it, use it. And so, interesting, gentlemen, what they came back and said is you're not disabled enough. Then they said their version of CART, real-time transcription, doesn't produce a real-time transcript. I appear in federal court and I get a real-time transcription. I've been in court in California. I get a real-time transcription from CART, and New Jersey as well. New York courts don't want us to have a transcript from CART because they don't want to have a record which can challenge theirs. And these transcripts are marvelous. The federal court ones, you can make them large print. I read an 18 bold print. Some of these judges' orders are like 3 centimeters long. I can't read them. I have a simple neuralgia, burning eyes and headaches from getting hit by a bus at my kid's school in 2013. And so New York courts have the technology. They won't turn on. And they'll say to you that if we provide CART, we'll give you a computer monitor where you'll have someone type the words, but you can't get a copy. You can't control the size. And so this is the problem. This is what necessitates things like what James Kelly's doing. We have a law, but you know what? New York Human Rights says we don't have enforcement over the courts for their procedures. So if you file a complaint with the New York Human Rights Commission, they say, oh yeah, they're wrong. They discriminate against you, but we don't have jurisdiction. So that necessitates what you mentioned, Roman and Matthew, going to federal court. You have an accommodation. You know I need it. You know others need it. You don't want to give it to us just because. You don't want to have a record which you can't challenge, because the computer takes down all the words and it's in the technology in the courtroom. So after I was jailed, as I mentioned before, similar to James, I sued a New York court administration in federal court pro se in 2018 in White Plains in front of Judge Karras. Couldn't get an attorney to represent me. Everyone feared retaliation if they sued the court, that their cases would be tossed or go to the back of the line. And so I got help from NILAG. I got some help from Disability Rights New York. No one would write the lawsuit, but they all helped. And, I was able to get in front of a judge to have a hearing and survive motion to dismiss in that case for 2 years. And that
Mark, I don't want to
judge-
stop. I don't want to interrupt you, but I just want, not everyone is familiar with the case. And, of course, we are united by a common theme here. We are fathers.
Sure.
Although, I had a mother 2 days ago on the show, right? So tyranny doesn't discriminate, and we need to be united in every sense, because that's what they're trying to do. But
Sure.
The cases started in the family court setting, right? Matrimonial court setting. So you are an alienated father. I don't know to what extent you want to go into the details, but that's how this whole thing transpired, right? So maybe you just can give a little background, how your general, involvement with the New York court system started. Because we are going to details, and that's good. People like it. I see that
Sure.
we are gaining viewers, but just maybe one step back so we have the background. Thank you.
I'm an alienated father only because they don't allow me to see my kids. Once COVID started, they stopped visitation. And after I had my second federal lawsuit, they cut it off as retaliation. So I haven't seen my kids. I've seen virtually. Last time I saw them in person was December 27, 19, while that case was being heard. And then I saw them virtually. Then it was just one or two of my kids, and then they cut it off completely in February 21. So if you can't see your kids, you're not allowed to, and you're not allowed to call, write, send gifts as retaliation because you sued in federal court and you had some judges, served by marshals. When you're informed pauperous, the marshals serve your litigation, and a judge has to authorize it. So I had multiple family court judges served in person with marshals in blue jackets and yellow, print on their jackets. And like you're saying, Roman, I'll begin by saying I've been in family court since 2012. Family court became totally one-sided once I was in a car accident in July of 2013. Kept on losing. Courts couldn't understand that you're forgetful. Courts couldn't understand that you're weak, or that you had bloodshot eyes, or that you were falling asleep in court, or that you need accommodations. So eventually, after my family court judge just kept me in family court with orders of protection reissued every month, I hired an American with Disabilities advocate named Donna Drum, who was a partner of David Bowie's, the lawyer who Representative Gore and Bush versus Gore in the election. And she was able to describe what we call invisible disabilities. I'm not forgetful. I need written orders. You expect me to remember written words, but my memory at the time, was 4% of a typical person in mid-40s. And even though a judge ordered forensic reports and got this, she didn't believe it. She says your representation that you don't remember belittles the record. You tell me what you did 2 years ago by taking the kids to Disneyland, but when I asked you why you were late for visitation by 5 minutes 3 days ago, you don't remember. You're lying. Oh, I wasn't lying. That's a symptom of post-concussion syndrome. And she was told it by advocates. She was told it by her own forensic people, and she didn't believe it. And eventually it got to the point where I asked for a note taker, because not only can't you get the transcripts, Rowan and Matthew, they make you wait 6 to 8 months for them. So by the time you get them, if you're in family court, as I was 2-3 times a month, the things have already changed, and a lot of them is audible. You don't remember what happened. Then they give you handwritten orders or verbal orders, and then expect you to remember them. You don't expect the person with post-concussion syndrome to remember them. So, the judge, instead of doing what we do in the disability community called reasonable accommodations, which are methods and programs to allow you to participate, like a blind person needs a cane, like a hearing person needs real-time transcription, like a mobility person needs a wheelchair. So we asked for accommodations, and that when the judge said, no, you can't have a note taker, you can't tape record, you can't video record, you can take your own notes. Oh, you can't use your arms, so what? I don't care. And you're not disabled because you're not in a wheelchair and you don't have crutches. And so that precipitated my first federal lawsuit. After a judge would not give me a final order I can appeal, and when I appealed the judge's denial of my note taker to the Brooklyn Appellate Court, they wrote it's not a final order. Went all the way to the Court of Appeals, who said it's not an appealable order. And so
not getting orders is something that we experience. I think all of us who've been to family court right now. James Kelly again. I have to mention that it's important, but we people who try to help him did not get any order. So yeah, that's just it's so prevalent.
Correct. And again, with the disability community and veterans, we need what's called maximum flexibility. You don't give someone with a traumatic brain injury a 5-minute window to do something. There was sometimes in family court, gentlemen, Westchester County has 3 courts: New Rochelle, Yonkers, and White Plains. They would schedule court appearances in all 3 courts to me in the same 4 hours. How was I possibly going to go there? I wasn't driving. I had an aid. You couldn't find parking. There's no handicap parking at some of these places. Of course, they made you late. Oh, you're late, so you're irresponsible. They purposely attack you when you ask for accommodations, when you ask for reasonable things. And in my case, they made the visitation and the orders so restrictive that it was impossible to comply. And so you have to go the federal route. And I have to tell you that I have had some success, and I'm having a lot more success in that same order, where the court denied real-time transcription on July 16, 2021, in case 20-1300, Fishman versus Office Court Administration. The Second Circuit ordered New York courts, Judge Shower, Michelle D'Ambrosio, Nancy Barry, Dan Weiss, to provide real-time transcription every court appearance going forward. Okay, and they didn't appeal it. It's law. We shouldn't have to go to federal court to get an accommodation. If you ask for it in California, Nevada, no big deal. You write to an advocate, you get it. Here, you have ADA liaisons in the court who will give you the accommodation. They say, but, if the judge overrides me, you got to appeal them to Brooklyn. Brooklyn Appellate Division, that also handles Suffolk County, where James is. They say, oh, you're not disabled. Are you people doctors? Did you read the medical reports, the forensic? No, you're not disabled because the family court judge says you're not disabled. Excuse me? I've had 24 surgeries. I have 8 implants. I have 2 batteries in my chest, leads in my head. Okay. I'm not disabled. I'm disabled with just one of the things: sleep apnea, peripheral neuropathy, neurostimulation, occipital neuralgia. I'm not disabled. Well, if no one will be disabled, no one will be accommodated. And if family courts aren't going to be flexible, then disabled and veteran parents are at a distinct disadvantage. And people like James and I, as well as you gentlemen, we want to make things more flexible so people succeed in family court, not set us up to fail. So during the same time where I was progressing to the Second Circuit to get that ADA accommodation order, I was on what's called a supervised visit. My supervised visitation was with a traveling disabled social worker. In Westchester County, those supervisors are called probation officers, no different than probation for criminals. Mm-hmm. And my probation officer would come and meet me every Saturday by 9 a.m. And we'd have visitation with my kids, my aide, who would drive, because I was not allowed to drive a car. okay, to pick up my kids where I live in New York City in Westchester and take them and have them until 5 o'clock that day. So we had a very a detailed 28-page visitation order, which said that I have no contact with my ex, and any contact is between the disability probation officer and the attorney for the children, the attorney for my ex. And if a visit is canceled, that's immediately made up the following week. So on December 15th, 18th, I texted my disability aide, who told me to come pick her up in Manhattan, where she lived. I lived in the Bronx, and my aide drove there. We got 3 texts confirming a visit. It was Hanukkah, okay, for those of us in the Jewish faith. And I said I wanted to give my kids gifts, and picked her up, and then proceeded to Westchester, where my social worker was calling my ex to confirm where the visitation was going to be. My social worker had us drive near my ex-wife's house. Okay, got out of the car. We were 4 houses away. Went to get my kids, and instead, my ex-wife called the cops and said I violated an order of protection for going on her property. An order of protection I was never served with. I had my order of protection that had a carve-out for visitation every other Saturday with the supervisor present. So after the supervisor came back to the car, drove to the police station, okay, and asked for a police report, and asked them to enforce my visitation order, and showed them my carve-out visitation, at which time, after questioning, before being read Miranda, the police arrested me for allegedly violating an order of protection for not going on my ex-wife's property with a visitation order, which a carve-out for visitation that the Brooklyn Appellate Court affirmed, said you could be near your ex-wife's house for visitation 10 to 5 Saturday. And the police did not accommodate me. I have an aide. I kept court papers in the car. Wouldn't let my aide come into questioning with me. Wouldn't call my doctor. Looked at my disability and my traumatic brain injury card and my hearing impairment. Wouldn't give me a notepad. Came in and basically after 45 minutes said, we're arresting you because you violate an order of protection. I said, I have a visitation order on violating order of protection. I haven't spoken to my ex-wife in over 3 years. I didn't go on her property. The order of protection that was told to me verbally, again, verbally for a person with hearing and memory impairment, okay, said, stay away from my ex-wife's house, the kids' school, workplace, except for limited supervised visitation every other Saturday. So cops arrested me without reading Miranda, denied my aid, denied me my records, disregard all the accommodations, and then directed my aide to drive the supervisor home and then come back to pick me up. And instead of accommodating my communication, they felt like they were putting my aide and supervisor under arrest. So I immediately filed violation petitions, okay, and immediately sued the cops in federal court for failing to accommodate my disability, knowing I was disabled, and false arrest, malicious prosecution, 1983 rights. And I'm happy to say that even though I was convicted in state family court in January 2020, that my federal case has passed, summary judgment to dismiss. Federal Judge Rahman in case 19-CV00265 NSR has determined the cops have no immunity, no sound immunity. They knew I was disabled. They knew I had a visitation order. They knew I couldn't read a 3-centimeter size print 28-page visitation order to describe that to them, but they knew that I had visitation and that my probation officer was there to effectuate it, and they instead arrested me for an unserved order of protection that was told me verbally was subject to visitation. But in the printed version, which I never got, okay, said complete stay away. So the visitation order I had was contradicted by the order of protection 2 years ago, which I never got, which was issued when I was in the quorum, and I never got a paper copy. My ex did.
So that's a lot of information, Mark. Let's break it for the viewers and also for us and for Matthew, to give his opinion as well. Matthew, please, you are a co-host, so just ask questions, as you will.
Free.
Yeah, we are getting people who are watching us. We are getting comments flowing in, and I wanna acknowledge them. So Eli Evans, who is a father, former retired NYPD officer. Many of you in New York know him as well. He said New York is the most corrupt country in the different than Tammany Hall. Yeah, and unfortunately, the parallels to to Nazi Germany, not see Germany, right? Not see is too many people do not see what's going on, are just coming to mind. Um, we have Julius. She's alerting Mark. Mark is, I think Mark is in California actually. So we have phenomenal people who are watching. Thanks everyone. Mike now is chiming in. It's not a civil matter. That's what we know about visitation. But so I'm just trying. I'm trying to understand. So you had a witness with you, right? And when you went there, with a witness to exercise your visitation rights, you were arrested, right? And you spent time in incarceration, and
So
significant time,
I
right?
had two witnesses. I had a court-appointed disability aide that had to be my ex-wife and the attorney for the children, as well as the attorney for myself and the attorney for my kids had to agree on. And I had a probation officer who did not violate me and who did not write a complaint, and who was completely disregarded by the cops. And we find out later, the benefits of federal court, that now there's video. There's 4.5 hours video that proves
Wow.
my ex-wife lied in criminal court because she called in that I was 2 houses away from her house, not on her property. But in court, she testified I was on her property at the border. And the cops testified they read Miranda when they before they questioned me, but the radio call and the video and the police station that we finally got October 13th this year, after subpoenaing the cops and deposing them in federal court, after 4 years of the cops saying there is no video and no audio.
We'll get to that. That's a very important point. I'm just trying to set the stage, for the benefit of those who have not read documents. And Matthew,
Sure.
you have anything that you want to comment so far?
I hear a lot about folks who want to bring with them a what I would call a human security blanket. You know how you see people bringing the dogs into the grocery store because they need the dogs to keep them calm or sane or what have you. Well, a lot of people want to bring in a human security blanket. They want to bring a friend or a relative or a cousin or somebody who's going to keep them calm. And I believe the ADA allows that. And so I know we're talking about other sorts of ADA protected activity, but it just made me think, as I hear so much about folks who want to gain access, that are friends of somebody going through the family court, and they want to be there essentially to, metaphorically hold their hand and try to calm them through the process. So I think that's an important right. I just wanted to chime in on that one.
And let me add, gentlemen, my son, my eldest son, is disabled. He's autistic. So an aide helps us have 4 kids. So if you go on a visit with 4 young children, I'd bring in an aide, assistant, or babysitter anyway, regardless. But the more the merrier, because an autistic child needs attention. But you're right, Matthew. In other states, it's no big deal. In New York, they'd say, if you're going to demand an aide, we're not going to allow visitation. That happened for months at a time. And then when they had visitation at their service centers, I got injured twice. They wouldn't let my aide in. I got a hernia at the Y in Westchester, with 4 active kids and 3 people, on clipboards, instead of helping me with my kids, said, your aide can stay outside. Excuse me? I had traumatic brain injury last year. Your aide can't come in. Your aide comes in, you can't have visitation. So again, civil rights violations are rampant, and that's why I guess the point of my call to you is when you need to go to federal court to exercise them, you need to, because these judges would look at you for an accommodation request and say that makes you a bad parent. No, getting flexibility and accommodation makes you a better parent because you want your kids to be safe, you want your kids to be happy, and you want your disabled kids to be accommodated.
Yeah, Mark. So we want to make this. I think Matthew will agree. These shows as educational as possible and as wide appealing as possible. So I see that there are 3 layers to what you are describing. You were violated. I'm not afraid to use this word. By the court. Then during your arrest by the police, right? That you were detained and then eventually jailed, and then in jail itself, right? So there were, like, broadly speaking, 3 layers to that. So when you filed your federal action, and that's the key topic, I think, that we need to do it. You did it on your own, right? You started as pro se, and then you had to somehow convinced, or your attorney was convinced that the case has merit. But you started as pro se. You sued all the layers that were involved in that chain of abuses, but judges were left off the hook, right? Can you speak about that?
So Roman, we have more than one case. So,
Okay.
I know we're trying to simplify it here. When I sued the cops, I had two other cases pending, including a case against the judges and the court administration. I want to emphasize it. I sued Office of Court Administration and later amended it to include judges in their administrative and official capacity for denying ADA accommodations to those of us who are disabled that the ADA liaison and the court agreed to. So state court administration said you can have the accommodation, but the judge says, like in James Kelly's case, no, you can't record in my courtroom. I don't care if you have an accommodation. It's my courtroom. I'm king. I'm queen. Tough. No accommodation. You don't like it? Tough. And it's very sad. And that's where, federal judges, I want to emphasize, you have good, you have bad ones like anyone else, but they are elected for life. And they do need to get confirmed by the Senate. And most of them take their job very seriously and very diligently and very polite. I've never had a federal judge be dishonest to me. And I've appeared in a lot of cases in my field in real estate and some bankruptcies, others, as well as federal civil rights litigation. I find a federal judge lets everyone be heard, whether they like the litigant or not. Whereas in state court, unfortunately, it's the exact opposite. Oh, we don't like you. You can't have a witness. Oh, we don't like you. You can't have an accommodation. Oh, we don't like you. You can't talk. Or better yet, you have a gatekeeping order. You can't even follow anything. And that's what they did. They did gatekeeping orders and still have them in effect. You can't follow anything without permission, and permission is always denied. That by itself violates your civil rights. Why? Because the judges didn't want to have to answer for repeated denial of disability accommodations. And so when New York's own regulator, human rights, wouldn't help, saying we have jurisdiction over the courts as buildings, not as procedures. Your issue is procedure. They won't give you an accommodation for your hearing and memory. Where do you go? You got to go to federal court. So,
you had pending you had pending cases for violating your rights, right? As person who is eligible to ADA accommodations. But my understanding is the more interesting developments, and again, more probably broadly applicable for the audience, are stemming from the arrest, right? So can you focus on that and just walk us through?
Sure. Mm-hmm. So again, in December 15, 18, during pre-approved, prepaid, I paid $500 a day for a visitation supervisor. Okay. Visitation pre-confirmed with a court order, with a visitation carve-out, with a confirmation text. When I was denied a visit with my son, and when I went to the cops to effectuate visitation and enforce the order and give me a police report just of the incident, they said, you're a convict. We're arresting you. Okay. Not accommodating me, not letting me show them an order, not looking at the order in the computer. They said, oh, there's another order 2 years ago, July 27, 17. Where were you? I was in jail. A judge jailed me because my daughter ordered off Amazon. And a judge said I violated an order of protection because the order of protection said I can only send gifts on major holidays. And my daughter ordered off an Amazon gift card on Easter. And the judge said it wasn't a major holiday, so you go to jail for 3 weeks. So this order of protection that was a complete stay away order that contradicted the visitation order from the same judge was never served on me. I was in jail. And I was in the jail hospital in Westchester County for 2 weeks. There was no record of the order being delivered to jail. There was no signing. And so when the cops questioned me and I attempted to communicate with them, I said, I don't have an order from July 27th. I was in jail. Matter of fact, in the jail hospital, they were on the federal monitor. So there were 4 cameras on me the entire time in the jail hospital. I didn't get any order of protection. What order of protection? Why would that order of protection cancel out the later one I got? No, this family court judge, Shower, wanted me to fail at visitation. So she would issue all these order of protection and she would never cancel the previous one, like is often done by practically every other judge. Okay, I issue an order of protection July 1. If I issue one August 1, the July 1 is voided. No, she kept all hers open. Well, we never got this one. And even though she said in the transcript, which I have, because I got a year later, said this order of protection is subject to visitation, I was arrested during visitation, and the cops knew it. And the cops withheld it because when we got to federal court and got the actual copy of the order of protection on the 3rd page, which wasn't introduced in criminal court, wasn't shown to me during the false arrest, it said this order has not been served. But the cops and my ex-wife said it was. So
yeah, and you discovered that later. I'm trying to build it in a sequential way. So But if I remember correctly, the case that you have pending now that's moving toward jury trial, and we need to talk about that because that's probably one of the key topics that we have to cover for our audience is
Sure.
how you survive the motion to dismiss, because that's the obstacle that everyone faces
Okay.
in federal court.
So let's go over that.
Mhm.
Plain and simply, we have Title II of the ADA, disability accommodations by state government. State government can't discriminate. State governments have to give you the preferred accommodation you request, okay, unless it's an undue financial burden or it completely alters the government process. Asking for a note taker to be in a courtroom isn't an expense for the court. Oh, I pay for it, okay, or Disability Rights New York or Westchester Independent Living will give me one for free, okay, and using real-time transcription to give you a real-time transcript might cost you a couple more pieces of pennies for paper, but it doesn't cost any money. It's not due to undue burden, doesn't interfere with the proceeding. The state court denied it. The day the state court issued that order of protection that I didn't get, and I was in jail, it denied my note taker entry to the courtroom. Denied her entry. You can't come in. No one can come in for you. Nobody. Just your attorney and you. Don't care. You can't take notes. Tough. What do you mean? So, they set you up to fail. And that's where federal court, you have no choice. So to answer your question, Congress waived sovereign immunity. Congress waived state sovereign immunity, even for judges in their official capacity, government agents that deny accommodations for disabled people. The infamous case is the 2004 case, Tennessee versus Lane, authored Ruth Bader Ginsburg, as well as Judge Stevens, which basically said there is no immunity for judges administratively or court administrators that deny access to a courtroom for a disabled person with a physical, mental, or invisible disability. So there is no immunity. But again, as Mr. Matthew will tell you, in his case, because it's very hard to survive sovereign immunity. We have in the case against the cops, I'm pleased to say, because of the benefits of being pro se and the obvious nature of the police writing I'm disabled in all these reports and not accommodating me, as well as their falsifying evidence reports, denying the video and audio, and making statements that knowing they weren't true. The cop was asked at the criminal trial, did he go on the property? No. Did he attempt to go on the property? No. Well, how could he be guilty of it? He went to the city of New Rochelle. He's guilty because he knows his wife lives in the city of New Rochelle. He shouldn't be in New Rochelle. I had a visitation order from New Rochelle. I have doctors in New Rochelle. 2 of my surgeons there. My dog's vet is there. My kid's school there. I can't be in the city of New Rochelle. It's cop said, you're in the city of New Rochelle, so you're arrested because you're in the city of New Rochelle. City has 120,000 people. Anyone be arrested for being in a city? They make things like, oh, you have 32 orders of protection in the last 8 years, so you're guilty. Luckily, we have federal Judge Rahman, who told the Quinn law firm, the go-to law firm for the cops in New York. He said, I don't care about the 32 order of protection. I just care about the 2, the one he has, which gave him visitation, and the one you knew he wasn't served with, which preceded that. I don't care that they have 30 other. Some judges issue order of protection like it's toilet paper. Every time you see them, they don't give you a copy. Oh, you saw me 2 weeks ago, order of protection, order of protection. You can't keep up with it. You don't remember it. And they're so tiny print, Roman, 3 centimeters. You can't read this stuff. You have people to interpret it. My attorney and my ADA advocate and my doctor said, listen to your probation officer. Listen to your supervisor. She says do. She said the visit was off Saturday the 15th at 10:10. I went to the police station to get visit with my kid. I only had two days a month. I asked for a police report. We can't give you a police report because you're a convict. Convict for what? Oh, you were in jail 2 years ago. I was in jail for confinement. I wasn't guilty of any crime. The judge confined me because she was upset. My daughter offered a $1,000 gift card off Amazon, and my mother and aunt sent gifts. And they said, you sent the gifts. I said, I didn't send the gifts. My
Mark.
judge even had, my aide come to courtroom and say, does Mr. Fishman go to Neiman Marcus or Claire's? Marc Fishman doesn't go to Neiman Marcus or Claire's. Ah, well, so what? Go to jail.
Let's shift a bit, toward the mechanics of your federal action, because it's based on past experience. Matthew, please add your perspective. That's what people can learn from your experience. And again, I want to acknowledge people who are joining. Thanks everyone. Please share. Please follow. It's very important that we keep the spotlight on that. I want to put a couple comments on the screen here. I do put them from time to time, but Terry's saying this is a positive movement in the country. It's coming this way. Just need to push. That's exactly right. We need to use the technology Even if the court doesn't recognize the technology, we need to use it, right? We have the ability to live stream. In the past, it would have taken millions to build a studio. Now we have everything readily accessible. Stacy is saying she can actually relate to what you just described. Same thing happened to me, and then a state representative came to see my case, and they sealed it the very next day. Another comment from her: would never allow me to have support in this courtroom. So I would like to just to understand the timeline as well, because you are getting toward the jury trial, right? But you filed it actually years back, right? And it took time for you to survive the motion to dismiss. But before that, Matthew, you have anything that you would like to ask the guest? You're quiet, which is uncharacteristic. So I'm worried now.
Well, I just have to say, I was, tripping on the comment earlier. Somebody said that I guess Westchester County is the most corrupt county, but I've heard it said that Richmond County is the most corrupt county. I've heard it said that Suffolk County is the most corrupt county. I've heard that Sacramento County is the most corrupt in California. I've heard San Diego is the most corrupt. I've heard Los Angeles, Orange County. I've heard San Mateo County, Tallahassee County, Florida. Even, the point is, everybody, wherever they're living, they believe that that court system is the most corrupt in the entire country. Oh my God, Cook County, Illinois. Let me tell you about Cook County, Illinois. It doesn't matter, everyone has the same impression. And that's kind of a scary thing, I think, in itself. I was just mulling this over in my mind, but it just goes to show you that this sort of communistic way of running a court system is endemic throughout the entire country. They're doing this everywhere. And I don't know. That was just my observation. I wanted to chime in a little bit there. So,
but Matthew and Roman, let me add this to you. I've requested these accommodations in the Bronx, Manhattan, and Staten Island. The ADA liaisons there and the judges have granted them. So you say to yourself, how could one part of the same court system like Westchester County deny them? Because they want you to fail. They don't want you to have meaningful communication. They don't want you to have clear orders. They don't want you to succeed because your ADA accommodations annoy them or threaten their sovereignty, or they have to give you an accommodation which they don't want to give you because they just want to find you guilty because they perceive you as a bad person because you can't remember, you can't hear, or maybe you talk a little loudly because you don't register well. Those of us had hearing and breathing problems. I was in speech therapy for years. I'm in mobility rehab now for my arm, for my fingers that go numb. I mean, the judges don't want to hear it. They resent it, and they resent the fact that they have to give accommodations, and they resent the fact that it interrupts some of their plans. But it is different in different court systems. And I agree with Matthew. Cook County, Suffolk, Orange County here, California, horrible. But we should have, at least in the States, one central place where you get an accommodation. What they tell you in New York, very simply, if the ADA liaison denies an accommodation, you can file an appeal to the ADA executive. But if that accommodation that you're awarded is denied by a judge, you have to appeal that judge to the appellate division. And Title II of the ADA says your appeal is supposed to be resolved within 45 days. The Brooklyn Appellate Division is the busiest appellate court in New York State, one of the busiest in the world. Try to get a decision, Roman, in less than a year and a half, 2 years. Okay? And then they don't explain it. Under the ADA appellate process, they deny accommodation, the grievance procedure, they call it. Well, there's a guideline on the USDA DOJ website, ada.gov, right? Those to read. It says you have to have a grievance procedure. The grievance procedure is, it's the Brooklyn Appellate Court. The Brooklyn Appellate Court just says, otherwise denied. They don't even describe why they denied the accommodation. They don't negotiate it. It's supposed to be an interactive hearing to negotiate it. I've been in interactive hearings alone and with my advocate, with my aides, where the adversary can't attend. They used to have my ex-wife attend. I wasn't married to her when I got disabled. And she'd be in there. Every accommodation denied. Or the best one, Roman and Matthew, is she would say, every single note taker I wanted to use, she's going to call as a witness. You're going to call my driver. You're going to call one of my managers. You're going to call one of my supers. You're going to call one of my relatives. Yes, everyone I'm going to call as a witness. So you have to pay a third party. Pay a third party? I'm disabled. I'm in rehab. I'm not working full time. Yes, pay a third party. Or you can't have a note taker. What are you talking about? You're never going to call these people. And that's where, again, we had to sue in federal court, and the judges got scared. Oh, a federal judge has his case of a denied note taker. It's not being dismissed. Judges are being served. Their aides are being served. They're having to come testify in federal court. Oh, we can't play the game of denying the note taker or making him pay a third party $100 an hour when you can get one for free. Yes, this is the level that they go through. But if you want me to go over the procedures in federal court, Roman, I'll be happy to say
Yeah,
the basics.
let's shift, more toward federal, because that's everybody experienced that. I would argue with you respectfully that I understand that the perspective that you are bringing as the ADA angle, it's very important, right? But I don't think courts discriminate. They just they don't care. Fundamental, whether you have a disability, whether you don't, whether you're a man, you're a woman, whether you have an accent, which I like to mention. You're an American, born and raised here. It doesn't matter, because it's an ideological institution, right? And the goal is to break the children, break the parents, and usher in completely totalitarian society. So we have constantly, in my opinion, that's my mission as far as I see it, to take a step back and see the larger picture. People here in the comments actually, are mentioning other counties. So St. Louis, Stacey has mentioned. Mike now is from Nevada. It is again. Yeah. So Matthew is familiar with that.
Can I just say Clark County, Nevada? I know a lot of people want to chime in on Queens County and Bronx County and Nassau County, but Clark County, Nevada, in my opinion, ranks highly here. But I had to say that.
It's a tough competition. Who is the highest? I think. So there's another mention here by Stacy. Thank you very much for chiming in. Thanks everyone. There's a linked Zoom call between St. Louis and Guardian ad litems, and that's a famous case, and I think nobody really took any responsibility so far as I follow the case. So it's a catastrophe, and Matthew and I, we talk about that all the time. But let's shift back to the federal case. So you filed, right? Of course, there was the government responded with a motion to dismiss, as they always do, but you were able to survive, right, against the part of those who you sued. And now the case is moving toward the jury.
Well, you see, that's the beauty. So let's go over that. And Matthew, feel free to chime in. So the beauty of federal court is these judges, they're elected for life. Okay. And most of them I find in federal court are professional and they're good people. They want to do the right thing. They sit there until their senior status. And so you can't just file a motion to dismiss. I'm sure Matthew can reiterate. The federal judges have their rules for their own courtroom, and many of them you have to ask permission. And if you're a court system, I've been a party to these for myself and other disabled people, and you're complaining that a government is not giving you accommodations, I find 9 out of 10 times that federal judge says, no, you have no permission to file a motion to dismiss. I want to hear more about the denied accommodation. When and if I give you permission to file a motion to dismiss, you will know, but you are not allowed to file now. And so, and you're pro se in federal court, certainly in the Second Circuit, New York, Vermont, Connecticut, the judges have to give you every benefit and every inference of being pro se and being a layman and not being an expert. So they have to interpret what you're saying, which for some of us with cognitive impairment hearing is difficult. I never had a federal judge deny my note taker entry. I never had a federal judge who wouldn't give me a free transcript. I never had a federal judge who wouldn't give me real-time transcription. They don't make an issue of an accommodation, and they don't even have to abide by the ADA. They have their federal rules of accommodation. So what I'm saying is that federal court helps because, unlike most states, someone just can't file a motion to dismiss. And then once the state has to defend and suddenly say, well, why was Mr. Fishman's note taker denied? Oh, it wasn't denied. He's interpreting the order wrong. I said, Judge, I don't read very quickly, but can I read you the order? I brought a copy for everyone. Mr. Fishman is denied tape recording, and he's denied permission to bring a note taker into the courtroom. That's what it says. Office of Court Administration, Attorney Lisa Evans. It doesn't say what you say, that he was denied permission for a note taker to tape record. It said the note taker was denied entry. And I said to the judge, here's my note taker. She was denied entry multiple times. She can't get into the courtroom. How can she take notes? How can I remember? I can't get a transcript. I can't get a final order to appeal. I appeal to Brooklyn, and they say it's not a final order under the New York Constitution, so you cannot appeal a denied accommodation by judge. That's when you got to go to federal court. And I found federal court is very difficult, very, 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 time-consuming, but with help of agencies and help of disability advocates, you can get through the pages and oftentimes convince the government to grant the accommodation or get an order for the accommodations. I did, even if you
How
don't win
long?
money, and
How
even if
long
you don't
did?
win a judgment.
No, that's helpful. We made this point actually, a couple times. But how much time have passed from the moment that you filed your federal complaint to the moment the motion to dismiss was denied?
So, in the current case against the police,
Mhm.
I filed my federal lawsuit pro se on January 2019. Okay. The other side wasn't allowed to put in a motion to dismiss until the early part of 2021. The judge entertained several preliminary conferences and wanted to see paperwork and accommodations and how they were denied and responses, and wanted to see orders. And that's when we started to get copies of what wasn't given to us in state court, a 3-page order of protection saying party not served, not the one given to the state jury. It said you were served. So once the judge got to see more and more of the case, on October 19, 21, still pro se, federal judge Nelson Roman in White Plains ruled that I made a prima facie case, meaning a basic argument that the police and the county and the city of New Rochelle, because the police work for the city of New Rochelle, violated my rights under the Rehabilitation Act, which is the Rehabilitation Act, Section 504, the Rehabilitation Act, 1973-74, okay, and Title II of the ADA. And he said that the police knew I was disabled. The police knew I asked for an accommodation. Police denied the accommodation, denied my aid, denied offering an alternative accommodation, failed to accommodate, and then retaliated, did an adverse action to me, arrested me for something I didn't violate, and creating a crime that didn't exist, and failing to give me the communication accommodation with my aid and the records I had in our vehicle to effectively communicate I didn't violate an order. They didn't want to hear it. And so that's what they're undergone now. And after I got that, then I got a civil rights attorney who agreed to take over the case. Says, "Oh wow, now you're going to win." Okay, and basically, the case was amended. Another motion to dismiss went in, and the ADA Rehabilitation Act survived, and 1983 charges have now been added. He also did something which is very good, which was because the chief cop who arrested me avoided service from me, from the court, from my attorney. After 2 years, the judge deemed him served. He said, "You know what? Mr. Fishman served your mother. He served your uncle. He served your aunt. He served the courthouse. Your supervised lieutenant. You're avoiding service intentionally. You're served. In order to make 1983 claims, you have to get personal service." So, the judge helped us in that regard too. Would make state judges say, "Look, if you didn't serve me, then serve me." So you do get help from some federal judges when they see a pattern of this.
No, that's understandable. That's all great, but we at least my approach is we don't need to sugarcoat things that as we see them, and of course it's great that you are making progress in federal court, but the point that I'm trying to make, maybe I'm wrong, is that it does take a lot of time
Absolutely.
to get justice in federal court, and you are still not at the stage of jury trial. So when is the jury trial scheduled?
If things go as planned, we'll have a jury trial in the first quarter of 2025. But as you said, Roman, things take time. I'm a disabled person. I've had multiple surgeries. I've had colon cancer. I've had a stimulator replaced. I've had infections. So, my health has delayed, particularly when I was pro se. And you had COVID. And you also have a judge who's in New York that have 430 cases. Basically, if you file a motion for a decision, you'll get a decision in 6 months. But I have to tell you, 6 months in federal court is a hell of a lot better than we wait for the Brooklyn Appellate Division or family court. My federal judge in family court wouldn't give me a final appeal or order until the 49th month I was in front of her. I went to federal court to get a final order because that's the only way you could have appealed the denied ADA accommodation. That's what's insane. That if you retaliate against a judge, you sue them in federal court, you sue court administration, they'll retaliate. They just won't answer your case. And I want to emphasize, judges have immunity. It's important to get the court system, the ADA liaison or the court administrator, or in this case, it was Nancy Barry, the director of court operations. I originally sued Office of Court Administration, and then I asked for injunctive relief against the operating officer of the court, Nancy Barry. I didn't ask for it against the judge. I asked for it against Nancy Barry for knowing I'm disabled, denying the accommodation when she had medical information, both confidential and public, that I was disabled, and failing to give the accommodation even though it didn't interfere with court. And that's what made it all the way to the federal Second Circuit. And that's what resulted in that order saying state court is ordered to provide the accommodation of real-time transcription. Okay, the case was amended several times. In federal court too, as opposed to motion to dismiss, what the judges say, instead of dismissing it, they'll say, Mr. Fishman or, disabled litigant, would you like to amend your case? Yes, Your Honor, I want to amend your case. How much time you need? So a lot of us, we try and put in a very simplistic case. Like I admire Matthew's lawsuit against the Judicial California. You want to make it very simple, but a lot of times, you have to be very specific. And in the case of the disabled person, give them specific instances, specific in minimal words, how they discriminate. I'm disabled. I showed them my disability card. There's video of it. They denied my accommodation. Here's the affidavit of my aide. They wouldn't let her help me. They wouldn't give an alternative. They wouldn't take me to a hospital. Their procedures book, manual be a police officer, says if you have a disability and they can't accommodate you, they take you to the hospital. Hospital was 5 blocks away. They didn't take me. They didn't want to. They didn't want to accommodate.
Well, that's just different perspective, right? You brought your own personal case, but what Matthew is targeting is essentially the policy, and there's the Monell angle, the lack of training. So Matthew is the expert to speak on that. We are over an hour here, and we are getting viewership, and I know that based again on past live streams, we'll get hundreds of people eventually watching that. So we don't want to belabor, I think, too much. We can always split and make maybe 2 shows like we did with the Matthew's case and Jason D'Souza, who joined us for the second part of it. But Matthew, my take, and that's how I view my activism, so to speak, and my role in this whole thing, tyranny that is unfolding, is bottom line is that you are proving your point, right? You are getting toward jury trial. You were able to survive a motion to dismiss, which is an immense achievement for those who try to file anything in federal court. But bottom line is, from 2019, right, until now, you still have not received the federal verdict. And of course, you got some improvements in your case, right? And you got access to materials that will exonerate you, hopefully, well, praying for you. But it takes 4 years, 5 years to get just to the point where you will be given finally an opportunity to prove your innocence, right? While all the way, in the meantime, you are still alienated from your children, right? Your rights are still not honored. You are in California fighting New York. So this system that put you in this position still exists, right? And,
Absolutely.
And to naively think that, federal judges don't know about what's going on in state courts. They come from state courts. My case is now being adjudicated in front of Judge Ann Donnelly, who is actually a former state judge, still on the state payroll, right? And she's dismissing my actions against Janet McFarland, who is the tormentor in my case, because they belong to the same clique. They belong to the same class of current and former state judges. So to just whitewash, I'm not saying that you are doing that, right? But to say that federal courts, they have no understanding what's going on, and that you will achieve your justice maybe 6 years, 7 years, maybe 5 years, hopefully for you, right? That's not the solution. That's not the answer. Matthew, you have a comment on that?
I think the federal judges are keenly aware of what's happening in family court, and I think also that the attitude, I could be wrong, but what I'm inferring is that a lot of the federal judges just don't want any part of family court, because they know that family court is a complete nightmare, and they don't want to get involved in court orders about whether little Timmy gets sent to school with a sweater, or whether Jenny gets peanut butter or doesn't get peanut butter in her lunchbox. And they look at it like it's not a proper, it's not worthy of the federal court. Like it's almost like in the federal court, they want to do important federal issues, and they look down on a family court and family court litigants. That's the feeling. I could be totally, misreading and being paranoid about that, but I've heard other people express the same sentiment, and so there may be some truth there. I don't know, but are they aware of what's happening? I think the federal courts are, and I think the federal courts need to address the issue, because if a state court judge robs you of a constitutional right, where can you go? Because generally speaking, all the state court judges, it seems to me, are going to be cliquish no matter where you go. And this is the sentiment that everybody says. And it's also, curious. Earlier, you'd mentioned how no attorneys will take a certain case, and that all the attorneys are afraid of retribution or their matters being pushed to the end of the line. It's like, how did we arrive in a society where everybody, all the professionals in that particular legal society, they anticipate and expect the judiciary will be corrupt if you try to stand up to them. It's just unfortunate that we've evolved or maybe devolved to that. I don't know, but that's my 2 cents anyway. So,
But Roman and Matthew, let me add to what you said. I want to answer what you said, Roman. My lawsuit began with 8 pages seeking education for every police officer and every member in New Rochelle to accommodate disabled people. That's what it sought. And it talked about the specific type of training. A lot of this training is offered for free. We have independent living centers in Westchester throughout the state, and they offer free accommodations for family, free teaching how to communicate with disabled people, free chiropractic, free PT. A lot of people don't know about services, because they're not widely advertised, or some people condemn asking for an independent living center for help, even though it's free. I've had independent living centers offer to do supervised visitation. So I want to bring it back to the point here, because, we got past that. And I want to emphasize, I have a federal judge who's a former police officer. He's a former Bronx cop for 8 years. He knows what a police arrest report looks like. He knows when it's fraud. He knows when cops did the wrong thing. And let me also emphasize that he's a libertarian. He looks at these, and what all too often happens, as you're aware, is your cases suddenly become relevant. Roman and Matthew. We had the Floyd case in Minnesota. Suddenly, the eyes are on the cops brutalizing people. Then we had Breonna Taylor, no-knock warrant, cops abusing their position. Then we had the kid in Memphis murdered by a cop because he's dating a cop's girlfriend. Then we have Lane Flesher, my case. It turned out my cop was accused before of harassing disabled people. He actually arrested a woman, who blocked a service dog from being hit with a baton by the cop who arrested me. The cop said the dog was barking. Well, if I was a dog, I'd bark at this cop too. The dog was barking. I was threatened, so I hit the cop. I hit the dog. You hit the dog in an orange vest next to a kid in a wheelchair with MS? Are you cruel? The same cop denied a Spanish interpreter to someone who's arrested. The same cop arrested a woman and a dog in a dog run, saying she didn't have the appropriate papers to be in a dog run. And yet none of this was given to me in criminal court, his disciplinary file. We have someone who hates disabled people, discriminates. So what I say is interesting is actually the point you made, Roman, is that we got to ask the supervisor, Officer Wenzer and Officer Schlesinger, do you have training to accommodate disabled people with communication or invisible disabilities? And you know what they said? What is that? And they said, excuse me? You saw Mr. Fishman's card. It said, call his neurosurgeon, call his father, call his AD advocate, give him a note taker, give him clear instructions, print out things double spaced. You give him a 3-centimeter order, you're expecting him to acknowledge it. He can't see. Let his aide come in, trained individuals with disabilities. They had no idea. And when we asked them to provide their training materials, they said they attended a class for Alzheimer's for 20 minutes once in 5 years. So the key, what I'm saying to you is education. Like Matthew is suing the Judicial Institute. You have to educate judges. You have to educate court administrators, and you have to do it regularly. Require that they do at least 5-6 hours a year to educate on civil rights, disability accommodations, accommodating veterans. A lot of veterans raise their voices with PTSD, but their ears have been blown out because they were in a war, a combat situation. They don't hear. They don't hear like you and I hear. They hear echoes. They don't hear yelling. So, and you need courts trained for the disabled. Like a disability court, like you have a drug court. And I think if you have education, most judges don't want to get caught discriminating because most judges know. Like in New York, we have the 0 tolerance policy. If your court denying an accommodation to a disabled person, you are fired. You lose your pension, you lose your robe, you lose your parking space, you lose your secretary and your court staff. So they fear disabled people asking accommodations. After I had the case in front of Judge Karras where I was allowed to have a note taker, I then went back to family court to reverse the decisions. The next 8 family court judges recused themselves, gentlemen. 6 of them I never met. And they all said, the secretary said, we don't want to get involved. Judge Shower shouldn't have jailed you because you're disabled and you don't remember or you can't hear. We want no part of it. That's the other thing we have in New York. the judicial codes of conduct. If you're a judge and you knowingly participate in disability discrimination by failing to accommodate a disabled person or veteran, you lose your judgeship. Commission of Conduct is supposed to take you, get and have a public hearing and say, that person asked you for an accommodation, they gave you medical proof, you knew they were disabled, you retaliate against them? I give you proof I can't hear or remember, and I need a written order and double space. You give me a handwritten note cut off where you give me 2 centimeters, expect me to read it when it doesn't have everything you said in court, and then you say I violated because I'm too smart, that I haven't proven to you I don't remember? No, my doctors proved it to you. Matter of fact, the doctors in family court in the directory of psychologists and neuropsychologists that you made me pay $166,000 for over 8 years proved I was disabled. But you disregard the reports because you said they're all false, that there's no way that I can't remember or hear well. No way. It's amazing. It's amazing what the steps they'll go. And it's sad that some of these people have a robe, because there are a lot of good judges. And yes, the key is education. The key is training. The key is to educate people like Judge Graff to work a solution with James Kelly and Tracy, his client, not to throw someone in a hole of a cell. All you're doing is empowering James. He's going to come out. He's going to file a federal lawsuit to sue these people, and we'll help him. Because it's ridiculous. You don't give him his glasses in jail. I have a simple neuralgia. I had to wear sunglasses all the time in 2017. The first thing I got back after they booked me was my sunglasses. They wouldn't give me a pillow. They had holes in my neck. They wouldn't give me a pillow. They said, you'll suffocate yourself with it. You're going to commit suicide. I'm going to commit suicide because a family court judge jailed me, okay, for my kid ordering off Amazon? I feel sorry for that judge. I'm not going to give her the spit off my mouth satisfaction that I'm going to hurt myself and commit suicide because of her. You're not going to get that at me.
Mark,
All they
it's
do
actually
by jailing us is empowering us, gentlemen. That's how they got filed the federal lawsuit.
that's absolutely right, and
I wrote the lawsuit.
That's absolutely right, and I think that's a good point, to jump off, because it reminds me that there's been a habeas corpus petition draft circulated among those who are trying to help James Kelly. So, and we've been respectably over an hour here. So I think you made a lot of very good points that people can go back and rewatch. Matthew, any parting words before we conclude the stream?
No, I just want to thank our guest and thank you, Roman, for a terrific job once again. And I always enjoy participating, and I hope that we can soon bring an end to this Holocaust.
Yep.
Amen.
So,
and thank you for having these podcasts, and thank you for exposing what often press don't want to talk about. And thank you, Matthew, for your federal lawsuit, and Roman for yours, because the more of us educate and follow these can effectuate meaningful change and also help others who are disabled who don't have the ability to fight. I got friends who are paraplegic. They have trouble moving a finger. How are they going to sue in federal court?
And non-disabled as well. We need to help everyone. This is tyranny.
Absolutely.
Tyranny doesn't discriminate. So thanks everyone for chiming in. Apologies for those that we couldn't acknowledge, but I see that Cheryl is watching. Carol Jean joined. Andrea joined. Josephine from New York joined. Free James Kelly. Indeed, that's what we need to remember, and that's what we need to make public. So thanks everyone. I think it's enough for today, and we'll reconvene in the next one. Thanks,
Let's
Mark.
get James home. Thank you, gentlemen. Thank you. Good night.
Thank you.